All right, welcome everybody. I think we're ready to get started. It is really my privilege and my honor to introduce to you Professor Paul Finkelman. He is one of the leading legal historians in the country today. Probably knows as much, if not more, than any other person alive about the history of slavery in the United States, which he's written a lot about. He's an incredibly prolific author. He has written almost 50 books and roughly 200 law review articles. So he's been busy for the last several years. But the topic today is birthright citizenship, which I'm sure all of you know is a pretty controversial topic right now. And he's going to talk to us about the original understanding of the birthright citizenship clause in the 14th Amendment. So without further ado, I'm going to turn it over to you. Thank you.
Thank you very much. Can you all hear me?
Yes.
And thank you, Dean Kaufman, for not only inviting me, but having a lecture series like this, because it is so important for all of us to think about the nature of American law beyond what we learn in the classroom or what we teach in the classroom. So all of you know, unless you've been living with Rip Van Winkle in a cave for the last 20 years, that there is a major issue concerning the United States in terms of when does one become a citizen. The history of citizenship in the United States is kind of weird because the Constitution, for example, says that the President of the United States must be a natural-born citizen. And yet nowhere in the Constitution does it define what a citizen is, nor does it define what a natural-born citizen is. Now, we all presume that a natural-born citizen would be somebody who was born in the United States and got citizenship at birth. But we could also, I suppose, make the argument that somebody born of a cesarean section is not a natural-born citizen, right? And therefore can't be president of the United States. I use that not to make fun of things, but to simply point out the indistinct nature of the document that was written in Philadelphia in 1787. And in fact, while there's discussions of citizenship in the United States in the Constitution, mentioning of it in a certain time, so for example, a member of Congress has to have been a citizen for 7 years, a member of the Senate has to have been a citizen for 9 years. Again, it doesn't tell how you become a citizen. It does leave the process of naturalizing citizens up to Congress. And this is important because at the time that the Constitution is written, all of the states are naturalizing people. And so every state has a different naturalization rule. But again, no one is defining what a natural-born citizen is or what a citizen is. And in fact, one might argue that the only way you could prove you were a citizen of the United States is if you had been naturalized, because then you would have a document. My grandparents, all four of my grandparents were immigrants, and two of them had their naturalization certificate framed on their wall. It was their most precious possession. The proof that they were citizens in the United States. But I don't know how I would prove I was a citizen of the United States. I mean, I have a social security card, I have a passport, but how does that prove that I'm a citizen? Because I don't have a piece of paper. I have a birth certificate that says where I was born, but it doesn't say natural-born citizen of the United States, born here. From the beginning of the country until 1857, the assumption was that anyone born in the United States who was a free person was a citizen at birth. And the reason I say free person, because of course in 1787, when the Constitution is written, slavery is legal in 11 of the new 13 states. And slavery will remain legal in the United States until until December 1865, when the 13th Amendment will finally completely abolish it. So a free person was a citizen if the free person was born here. Now, citizenship comes with a variety of rights, both common law, historical rights, and modern rights. So, for example, under English law, you could not inherit real property. We've all taken Property 101, you know what real property is. You could not inherit real estate if you were not a citizen of the United States. There is a case in the 1840s involving a woman who is born in the United States by her parents who are visiting the United States from Great Britain. She lives in the United States till she's about 11 months old, and then they move back to Great Britain, and she spends the rest of her life in England. When she's in her 20s or 30s, been in England a very long time, her uncle dies and wills his estate to her. Her uncle lives in New York. She gets nice prime New York State real estate. And the collateral heirs of the uncle, of course, complain, well, she can't inherit because she's not a citizen of the United States. It goes to the highest court in New York, which concludes that because she was born in the United States, of effectively parents who were tourists, who were not planning to stay and who did not stay, she was a citizen at birth, and since she has never renounced her citizenship, because actually she didn't know she was a citizen, she was entitled to inherit. So that's the application of the old common law rule, okay? Now, that could be overcome by statute. So, for example, after the American Revolution, the treaty with England, and of course a treaty becomes the law of the land under the Constitution. Treaty with England allows some British citizens to inherit land in the United States that their family had owned in the United States before the Revolution when it was a British colony, okay? The Constitution says the president must be either a natural-born citizen or a citizen at the time of the adoption of the Constitution. So, for example, if you had been a citizen of another country and came to the United States during the Revolution, then you could be eligible to be president of the United States, because you were a citizen at the adoption of the Constitution. Obviously, that is no longer relevant to American law. As far as I know, there's nobody alive who's, coming up on 250 years old that could claim that. But what it means to be a natural-born citizen is not entirely clear. Let me give you the example of Admiral and Senator John McCain. Okay, John McCain was the son of a naval admiral. He himself is later promoted to admiral after he comes back from having been a POW in Vietnam, and then he becomes a senator. And then he wants to run for president. The problem is, John McCain was born in Panama, while his father and mother, because his father was an admiral, he could bring his wife with him to his posting, while his father and mother were living in Panama because that's where his father was posted. Under U.S. law at the time, if you were born of an American father, not an American mother, but if you were born of American father overseas, when you came back to the United States, you could get American citizenship instantly. But you had to ask for it, you had to apply for it. So I would argue that John McCain, whatever other qualities he had, was ineligible to ever be president of the United States because he was not a natural born citizen. He was what we would call a statutory citizen, right? The essence of natural born is you don't have to do anything. You simply have to be born here, you know? The famous comedian, intellectual, public person, Will Rogers, who was born in Oklahoma in a tribal community on a reservation, talked about how when he first asked for a passport, they said, where's your birth certificate? He said, well, you know, we didn't need a piece of paper to prove we were born because we were born, right? He could eventually get a passport because he could prove he was born in what was then the Oklahoma Territory and later became the state of Oklahoma. But he was a natural born citizen, perhaps, and we'll get to that in a little bit, all right? So the very notion of who's a citizen is not crystal clear and never has been crystal clear. By the way, a year after John McCain was born, Congress changed the law and said that anybody who was born in the canal zone, which is the Panama Canal, or in Panama in a military base, would be a citizen at birth. So presumably, Congress can change the definition of natural born to include born in a particular place, born inside an embassy somewhere, for example. But until Congress did that, the other rule was that you weren't a citizen until you came back. By the way, just to complicate things further, because this is after a law school, and there are many law students here, and my job as a law professor is always to confuse you, right? So just to confuse you a little further, it is possible, under present American law, you are a citizen at birth if your parents are citizens when you are born, no matter where you are born, okay? However, it is possible to be a child of an American citizen and not be a citizen at birth. And let me give you the complexity of this. We have family A, both American citizens, move to Paris and decide that, you know, Napa's good, but it ain't Bordeaux. And they're going to stay in France the rest of their lives, and so they do. Second family moves to Paris, same circumstances. They both have children. One has a daughter, one has a son. Those children are citizens of the United States by birth, right? They could get an American passport. They could claim U.S. citizen at any time. But they never go to the United States. Their parents have no interest in going back to the United States. They live their entire life in France. They meet each other, they get married. So now you have two American citizens who've never set foot on the United States soil. Their children are not American citizens because under American law, if the parents born overseas have never, ever, ever come home, they can't pass on citizenship to their children. Does all of this seem complicated? It is. Okay. Now, yes, and by the way, please feel free to raise your hand. You know, I'll call on you. You'll get extra points on your exam score when you're done.
For that scenario, how many years do they have to be on American soil for their children to be considered citizens?
I don't know, 5 minutes.
Oh,
They simply have to come here. Yeah, so if they fly to Kennedy Airport, they go through customs, they're now in the United States, they can take the next plane back to France. They simply have to show up. Okay? It's weird. And I'm by the way, I'm trying to find a case on this because I haven't, but I'm sure there are cases somewhere. Somebody's litigated this because somebody always litigates something. Everything, right? Okay. So, until 1857, this is the rule in the United States. Born here of a free mother, and this is again important because the status of a slave was matrilineal, even though citizenship in the United States and many other places was patrilineal. So if your mother was a slave, you were a slave no matter what your father was. To use the most famous example, the children of Sally Hemings are slaves, even though their father is the third president of the United States, Thomas Jefferson. Because their mother's a slave, they're a slave. So they're not natural-born citizens of the United States because they're born as slaves, okay? But until 1857, everybody else born in the U.S. is seen to be a citizen. I'm mic'd.
It keeps cutting in and out.
Do you need to do something to me?
I was gonna just resync it real quick. It'll take me like a second.
Okay.
Yeah. So I need to get the mic off.
Oh my God.
Yeah. That's technology for you, you know?
Okay, there you go. Can you all hear me?
Yeah.
I will yell. I can be like a lounge singer now, right? Okay. I left my heart in Santa Clara, right? Is this on?
Yeah.
Okay, good. So I'll use this for the moment. So then we get, of course, the infamous decision in Dred Scott versus Sanders, where Chief Justice Taney rules that no black person born in the United States can ever be a citizen in the United States, even if they are born free, even if their parents are not slaves, because by 1857, of course, while slavery is legal in 15 states, it has been abolished in 17 others, including California. All right? So Taney says that free black people born in the United States cannot be citizens. He acknowledges, he concedes that they can be considered citizens of the state where they live, which leads to a really weird other problem. Because by the late 1850s, African Americans could vote on the same basis as white Americans in Maine, Vermont, New Hampshire, Massachusetts, and Rhode Island. And they could vote if they owned a certain amount of real property or paid real property taxes, which whites did not have to do. They could vote in New York. They could vote in Michigan. If they owned property, they could vote in school tax elections, because in order to have a school tax, you had to have a certain percentage of the property owners vote for it. So there's all kinds of weird things like that. Furthermore, while African Americans could not vote in Ohio, they could hold public office. And in fact, in Lorain County, Ohio, which is just west of Cleveland, the county attorney was an African American lawyer who was elected county attorney in Lorain County. There was a judge in Massachusetts by this time. In 1860, there would be an election judge in Rhode Island. So there are scattering examples of blacks holding public office, and blacks are voting for members of Congress in a handful of states. They are voting for the state legislatures, which are then choosing senators, because we don't have direct election in the Senate yet. So you have this very weird situation that Chief Justice Taney essentially says that non-citizens can vote if the states want them to vote. Now, again, I'm not going to get into the great details of non-citizen voting in this country. But the reality is that virtually, I shouldn't say virtually, every study of voting in the US, going back for the past 25 years, shows that almost no non-citizens have voted in any elections. In 1 year, they found like 32 people in the whole country who were possibly non-citizens who voted. There is the paranoia, the fear, the political noise about non-citizen voting is simply, I hate to use the term, but it's the only one that applies. It's fake news. It's made up. It's not real. Okay. But in the 19th century, non-citizens could vote in lots of states. And in fact, they did. Because states would say, if you are an immigrant and you have declared your intention to become a citizen, then you could vote. And after all, what was the American Revolution about? Taxation without representation is tyranny, right? So if you're a non-citizen, shouldn't you be able to vote on those people who are taxing you? Because you should have representation. And that was the theory in the 19th century. Okay. But Chief Justice Taney says African Americans, no matter where they live, are not citizens in the United States. That is the rule going into the Civil War. After the Civil War, Congress passes the Civil Rights Act of 1866, in which it declares that all former slaves are citizens of the United States. Now, there is a question within the Congress by people who supported the 1866 Act as to whether it was constitutional. And so the same Congress that passes the 1866 Act also writes and passes and sends on to the states the 14th Amendment. And what does the 14th Amendment say? The first line, line 1, section 1, all persons born or naturalized in the United States and subject to their jurisdiction. There is because the United States is seen as a plural noun rather than a singular noun, as we would use it today. So all persons born or naturalized in the United States and subject to their jurisdiction are citizens of the United States and of the state in which they reside. So if you were a former slave born in Mississippi, you are a citizen of the United States and you are a citizen of Mississippi. And if you move to Alabama, you are now a citizen of Alabama. Now, the question that some people raise is whether undocumented migrants are not citizens because they are not subject to the jurisdiction of the United States. So let me talk about that phrase for a second. First of all, if undocumented migrants are not subject to the jurisdiction of the United States, then if they commit a crime, we cannot prosecute them, right? Because they are not subject to our jurisdiction. If they murder somebody, we cannot put them on trial for murder. If they steal something, we cannot put them on trial for theft. We can deport them because they are not citizens and they're not subject to our jurisdiction, but that's all we can do. Now, I'm certain that nobody in the current administration, which wants to change the meaning of the 14th Amendment, would say, oh yeah, well, we believe that. Of course they don't believe that. But they would, if you're not subject to our jurisdiction, you can't be tried. So who isn't subject to the jurisdiction of the United States? First category are diplomats and their families, right? The ambassador from any country and that person's spouse and children are not subject to our jurisdiction. If that person commits a crime in this country, the only two things we can do is to complain to the home country and ask them to waive diplomatic immunity, or we can expel the diplomat. You want to see this in action? go to New York City and look at all of the cars which have diplomatic license plates that are parked in front of fire hydrants and are parked in no parking zones. And there are tickets because the cops put the tickets on and the embassy throws the tickets away because guess what? Their cars are not subject to the jurisdiction of the United States. All right. Second category would be enemy soldiers who have invaded the United States, okay? Now let's see, when was the last time the enemy invaded the United States? Anybody know? When was the last time there were foreign soldiers, not Venezuelan drug dealers?
1812.
Okay, the War of 1812 would be the logical choice. But there was one much, much later. During World War II, a small part of the Japanese Imperial Army seized two of the westernmost islands of the Aleutian Islands. And since Alaska, while not a state, was part of the United States, by the way, nobody lived there. So they were there for a little while, and then they left, okay? But those are the only two times since the American Revolution when we have an invading army in the United States. So the invading army issue is not particularly relevant. The other interesting thing, of course, is if you had an invading army, the army would have to be here at least, presumably, a fair number of months for somebody in that army to actually birth a child who would not be a citizen, right? Okay, so there's a third category. In 1868, at the time the amendment is written, there are large numbers of Native American nations all across the West who are inside the United States. North Dakota, South Dakota, Montana, Wyoming, Idaho, parts of California. They are in the United States, they are owned by the United States, but none of the people living there who are Native Americans are subject to the jurisdiction of the United States because they are living in their own nations, and the United States has never attempted in any way to enforce its laws on them. Okay? If you want to see a real live example of that, go read about what happened to George Armstrong Custer when he entered the Sioux Nation in the Dakotas, okay? That's Indian country. It's not subject to the jurisdiction. And so sometime after the Civil War, the Supreme Court ruled not only were Native Americans in unsettled, unorganized Western territories citizens. I'm wondering if I'm ever going to get my lapel mic back.
You're not.
You're not?
You're not. You just told me you're not.
Well, okay, that's not very nice. So far, everybody here has been so nice, and I like that mic. Anyways, my hands are getting tired. Okay, so the court ruled that anybody who is born on an Indian reservation and is there, and therefore is subject to the jurisdiction of tribal law, is not a natural-born citizen. Later, Congress would change that. In 1924, Congress would say everybody born in the U.S., including people on reservations, it's the American Indian Citizenship Act, they're citizens. By the way, this raises a interesting question, because what was the status of Indians who were born in tribes before the Indian Citizenship Act? Did they become citizens after the Indian Citizenship Act, or were they still non-citizens because they were born on reservations, okay? And that raises another interesting question, because now here's your trivia question for the day, okay? Who is the first non-white Vice President of the United States. Here in California, you all think you know, right? Well, it's not Kamala Harris. It's Vice President Charles Curtis, who was elected in 1828. Charles Curtis is a member of the Kaw Nation, born on an Indian reservation in 1860, before the passage even of the 14th Amendment. And he is also a member of another Native American tribe. And he is an Indian tribal member. His father happens to be non-Indian, so he has both possibly U.S. citizenship, but since he's born on a reservation and is a tribal member and is an enrolled member and inherits land from his mother, because in the Kaw Nation, inheritance is matrilineal, he's our first non-white vice president. But the really interesting question is was he a citizen at all when he was elected? Nobody seemed to care, okay? Hoover chooses him because he had been Senate Majority Leader. He was a very powerful U.S. Senator. And so he's vice president. But these little issues kind of gnaw at us when we begin to think about sweeping things. Now, let me get to the great crisis at hand, because the current occupant of the White House said when he became president that when asked about citizenship said, "We're looking at that very seriously, birthright citizenship, where you have a baby in our land, you walk over the border, have a baby, congratulations, the baby is now a citizen of the United States." And of course, the president wants to get rid of this. He doesn't like it. He thinks this is bad policy. And the president goes on to say, it's frankly ridiculous. Well, it's not frankly ridiculous. It happens to be the U.S. Constitution. But then perhaps the president thinks the U.S. Constitution is frankly ridiculous. Now, here's one other thing to think about when you think about birthright citizenship. The 14th Amendment does not talk about the status of the parent at all, right? It does not say all persons born in the United States of U.S. citizens, or all persons born in the United States of people legally living in the United States are citizens at birth. It doesn't care who your parents are. It only cares where you were born, which, by the way, was also the essence of English law that we inherited from England during and after the Revolution. If you were born in England and you weren't the child of a diplomat or an invading army, and they didn't have Native Americans, so they didn't have to worry about that, you are a subject of the monarch. You owe fidelity to the monarch. You can be called up to serve in the monarch's armies, etc. So that's what the 14th Amendment says. Now, in the 1970s, two quite serious academics, Peter Shook, who was at Yale Law School, and Roger Smith, who was then a professor in political science at Yale and is now at the University of Pennsylvania, wrote an article called Citizenship Without Consent. They wrote a book called Citizenship Without Consent, in which they argued that at the time the 14th Amendment was ratified, there was no such thing as an immigration regulation. And therefore, no one in Congress could have imagined undocumented aliens living in the United States. I'm going to take about 5 minutes to explain this and then turn it over for questions, okay? The second point is really bizarre because you have two highly trained, smart academics. Roger Smith, by the way, is a good friend of mine. He's just wrong about this. He's completely wrong. But did Smith and Shook believe that the people in Congress could not imagine immigration restrictions? Do they think that people like Charles Sumner were so stupid that they couldn't imagine immigration restrictions? Well, let's look at the immediate history of the US. Starting in the 1830s, there are a series of political parties known as nativist parties. The nativists are anti-immigrant. The most famous is the Know Nothing Party. It was actually called the American Party, which I think is the name of Elon Musk's party, right? Which figures. And the Know Nothing's campaign was that no Roman Catholic, it's a great place at this school to discuss this, right? No Roman Catholic should ever be allowed to hold public office in the United States. Because after all, they are subversives who will not follow the Constitution, they will only listen to the Pope. I'm wondering how they would feel about an American being the Pope, but that's a whole different question, right? You know, raises all sorts of interesting things. Can the Vatican say, well, he shouldn't be Pope because he's going to follow the Constitution? Okay, won't go there, but it would be fun. Okay, so that's one of the Know Nothings provision. The other provision is that to become a naturalized citizen, you have to have lived here consecutively for 25 years, 21 years. If you went home for your mother's funeral, you lost your road to citizenship and you had to start all over again. In 1856, the Know Nothings carry the state of Maryland, and they carry 21% of the popular vote. In 1852 to 56, Know Nothings had captured the state legislatures of a number of states. Everybody in the Massachusetts legislature, but I think one person was a Know Nothing at one point. There were Know Nothing mayors all across the country. There were Know Nothings in the Senate. And the Know Nothing political goal was to prohibit immigration from most countries, to prohibit non-Protestant immigration from Europe, and to make it extremely difficult for immigrants to become citizens. So to say that Congress couldn't have imagined such laws is to say that Congress was simply unaware of the history that they had lived through. Similarly, and this is the really important things, there were in fact laws on the books prohibiting certain people from being here and prohibiting certain kinds of immigrants. In 1798, Congress passed something called the Alien and Sedition Acts. Our current president wanted to use the Alien Acts to kick people out of the country, saying that they are alien enemies because they are dealing drugs. But the problem with that is to be an enemy, you actually have to be at war with somebody, which he kind of missed that part, right? But he thinks the Alien Acts are still on the books, and they are. And what do the Alien Acts say? They say that in time of war, the United States can deport any person who is a citizen of an alien enemy country. They were passed in 1798 because the Adams administration thought we were going to go to war with France, and he wanted to kick all the French people out of the United States, as well as because by this time Napoleon had conquered much of France, other European countries as well. We don't go to war with France, but we do go to war with England. And in the War of 1812, as somebody pointed out, and the British invade us. And we expel a few British citizens as alien enemies. But if you were designated an alien enemy and designated for deportation, and you somehow evaded that deportation, you went into hiding, you moved to the wilds of Kentucky where they couldn't find you, and you stayed in the United States and then had children, under the 14th Amendment, your children would be citizens of the United States even though your parents were not legally allowed to be in the United States. In 1803, Congress passes a law prohibiting ships from bringing free black people into the United States, not slaves. This isn't the African slave trade regulation. This is free blacks can't be brought into the United States to any state which prohibits free blacks from moving into those states. But we know that ships did that. So those people would be undocumented, illegal migrants living here, subject to deportation. Furthermore, starting in 1819, Congress passes a series of laws which says that if anybody illegally imports a slave from Africa, that person cannot stay in the United States, cannot be held as a slave, but must be returned to Africa, and that's the creation of the country of Liberia, with the capital city of Monrovia, named for President James Monroe. Okay? So we know that there are lots of slaves smuggled into the United States from the 1820s up through the eve of the Civil War. Congress knows this. There's scandals about this. Ship arrives in Georgia full of Africans who are going to be sold. The U.S. Marshal arrests the ship owner, takes all the Africans on board and puts them in a jail as for safekeeping, not as prisoners. And then somebody comes along to the Marshal and say, you know, why don't you rent those people out to me? I could use some labor, and then you don't have to pay for their upkeep. Those people disappear into the slave communities of the United States. So we know in 1868 there are people in the United States who are there illegally. And yet Congress passes a law which becomes the 14th Amendment, proposes an amendment that says all persons born, doesn't care about their parentage. During the debates over this, one senator who is opposed to birthright citizenship says, under this rule, it looks as though, and I'm going to use a term that is offensive, but it's the term that's in the congressional record, so it's in quotation marks. Under this rule, the children of Chinese and of gypsies, I don't know how many Roma people there were in the United States, not very many, but the children of Chinese and gypsies would be citizens of the United States. And Lyman Trumbull, a senator from Illinois who'd written the 13th Amendment and was a good friend of Lincoln, just looked at this senator and said, undoubtedly. And no one disputed that. When the vote comes, the California delegation says, we don't like this because we don't like Chinese becoming citizens of the United States, but we'll deal, and they vote for it. Same thing from people in Nevada. The Oregon delegates vote against it, they lose. So what we know is that from the very beginning, there was hostility to certain immigrants, there was hostility to citizenship, and the Congress did not care. So when we think about the issue of the 14th Amendment today, the issue is very clear. If the sitting resident of the White House wants to get rid of birthright citizenship, there is a process for doing so. It's called a constitutional amendment. And all I would say to that is good luck. Or bad luck. Let me take questions if you have any.
Go ahead and raise your hand and I will call on people and the Dean Comfortable will come around with the mic for anyone who has questions. In the back.
The gentleman in,
You can't do this.
wait till the microphone gets to you. And by the way, I just gave a talk on baseball in the sports law class, so you're properly dressed to ask this question.
No, one class late. So if he can't do this without a constitutional amendment, then what is all this? What's going on now with all this hula law, or whatever you want to call it?
Well, okay, so what is going on now is that my own view is this, that the president or his advisors are simply claiming to be able to do this, claiming that people who are here without documentation, that their children were never meant to be citizens of the United States, making it up out of either thin air or making it up based on the Roger Smith Shook book. By the way, Roger Smith is totally against this. He believes in open immigration. He just thought that he was being an honest scholar. He just wasn't, I think, as good as he should have been about it, or he wouldn't have said it. But look, I don't want to get too deeply into present day politics, but what we're seeing is a constant assertion of presidential authority that has never been previously asserted by executive orders in ways that they have never been used, and a kind of a daring the country to push back, daring the courts to push back. It is incredibly dangerous if any of this comes to fruition. But that's the only answer I can give you.
Sorry, can I just add one thing? So the president did issue this executive order on birthright citizenship. It's currently not being implemented because there are 4 different federal courts that have said you can't do this. And so it's not actually being carried out by the executive branch right now because it's held up in courts. So that's sort of where it stands at the moment.
But by the way, I'm signed on in an amicus brief in every one of those cases. Other questions? Yes, sir.
Yeah, I don't think I need that. What do you think the current Supreme Court is going to do if the issue is squarely presented?
Okay, the question is, what do I think the court will do? I'm a historian, not a fortune teller, but I actually believe that the current Supreme Court, by a vote perhaps as much as 7-2, will say that the president cannot do this, that the 14th Amendment means what it says. I certainly believe that Chief Justice Roberts, who I don't always agree with on many things, does not want to go down in history as being the Roger Taney of the 21st century. He does not want to be listed in the scroll of infamy for judges who did awful things. And I think a majority of the court will say the same thing. By the way, in 1898, there was a case called Wong Kim Ark versus United States. Wong Kim Ark was born in the United States of Chinese parents. He went back to China to visit family. He comes back to the United States, and the immigration people won't let him come in because they say, you're not a citizen. And by the way, we have passed the Chinese Exclusion Act. You're excluded. Case goes to the Supreme Court. The court rules 7-2 that, in fact, if you were born in the United States, you're a citizen. And this, by the way, the court that does this is not particularly sympathetic to Chinese Americans. It is not sympathetic to Chinese immigrants. It does not rule usually in favor of Chinese plaintiffs. And by the way, some of these cases are pretty weird. Like there's one case where a person of Chinese birth who's not a citizen. Oh, by the way, I should add, under the Naturalization Act at that time, before 1870, only white people can become citizens under the Naturalization Act. And after 1870, only people who are white or of African or African American ancestry can become citizens. So Chinese are still excluded from naturalization, as are people from the Philippines, the Pacific Islands, Latin America, parts of Asia. Okay. By the way, again, we never define what white is, which is also, okay, so let's define it. What does it mean? Nobody ever wants to do that because they wouldn't know how to do it. But in one case, the Congress passes a law saying that if you are a Chinese immigrant who is legally here and you leave the country, you have to file a certain amount of paperwork in order to come home. There is a Chinese immigrant who is in China when this law is passed. He comes back to the US and immigration says you can't come in, you didn't file the paperwork. His response was, well, there was no paperwork to file when I left. Supreme Court says, too bad, so sad, you lose. So this is not a Supreme Court that is, in other words, sympathetic to Chinese immigration or later to Japanese immigration. But in Wong Kim Ark, they make it very clear, under the 14th Amendment, there's no doubt that this is what it means. So my prediction is that the court will rule that if you're born here, you're a citizen. I could be wrong. I have a feeling that Justice Alito and Justice Thomas will find ways to get around that language. But again, maybe it'll be 9-0. Maybe they'll be, say, look, this is the rule.
Take one last question here and then we got a break. Go ahead.
Thank you so much for this incredible talk. I'm really grateful.
I'm sorry, you got to talk louder.
I can't. My voice is really small. Sorry. Thank you so much for this talk. I'm really grateful to be here to hear it. I'm wondering. I'm also glad that you mentioned the status of Native nations during.
Could you hold the mic close to her mouth so I can hear her?
Can you hear me now?
Better.
Okay. I'm glad to hear you talk about the status of Native nations in the 19th century and how it relates to citizenship. Because in the most recent executive order, they actually cited a federal Indian law case, Elk v. Wilkins, to justify their stance on banning birthright citizenship. So I'm wondering if you could say a little bit about why they chose Elk v. Wilkins in that executive order.
I am terribly sorry, but I actually can't hear the question. Could you repeat it for her, maybe? I realize that she's having trouble. Would it?
Yes,
in the latest executive order, they cited Elk v. Wilkins.
And I'm wondering if you can say.
Okay, so Elk v. Wilkins said that Native Americans were not subject to the jurisdiction of the United States. Congress reverses remember, Elk v. Wilkins is essentially it's not a constitutional law decision, it's an interpretation of language. And Congress overturns that language in the 1924 Indian Citizenship Act. So since 1924, every person born in the United States in a reservation or in a tribal community is a citizen of the United States at birth. That's a statute. So they can cite Elk v. Wilkins, from now until the end of time. But unless they want to deal with the 1924 Indian Citizenship Act, there's nothing else to say because that act overturns the court's interpretation. Now, I suppose, in theory, the Supreme Court could say, well, Congress can't reverse a Supreme Court opinion by statute, and therefore people born on reservations are not citizens of the United States. That would be beyond weird. And furthermore, that doesn't get to what the current administration wants to do. What astounds me about all these executive orders is I assume they're being written or drafted by people who went to law school somewhere. And I'm wondering, are there some kind of educational malpractice cases that need to be brought at the schools where they went? Because this is really, quite frankly, flagrantly awful lawyering.
Well, I think maybe we should end on that note.
I will end on a different note. All of you who are here, your job, your role as law students, as lawyers, as law professors, is to go out and do justice. And all